because the bandwidth and the interruptions and the, sometimes the echo will interfere with the speakers. This workshop is being recorded, and Darcy just turned that on. Darcy is our tech contact for this panel. She will put her email address into the chat function. So if anybody starts to have some tech issues during this panel, please feel free to email her so she can assist you. And after all our panelists speak, we're going to give some time for questions. Those can either go into the chat function of the Teams meeting, which if you are using the app itself, there's in the top right corner, there's a bubble that looks like a show conversation chat function, which Michelle is lacking today. If you are using the web-based version, if you toggle your mouse over the center of the screen, a chat function should pop up. And also towards the end, after all the panelists speak, you can also raise your hand and, put your camera on and speak your questions verbally. That being said, tech does have we can reserve the right to turn anybody off if anybody's being a little bit too unprofessional or not keeping themselves muted while the panelists are talking. So we just want you to be aware of that. Also, there's closed captioning features. So if you were to toggle your mouse over those same places, you can select the closed captioning features if you require that assistance. So like I said, we are here today to talk about the Me Too movement and sexual harassment. And so just very briefly getting started, we've heard a lot about the hashtag Me Too movement in the last few years, but I think a lot of people might not know where it stems from. They know what it means, but they might not know where it stems from. And for those of you that don't know, the commission has a very robust diversity and inclusion committee that produces like a lot of educational materials on Instagram and Facebook. And they did a really good analysis of where Me Too, hashtag Me Too came from. And the fact that it was actually started way back in 2006 by Tarana Burke in a post on MySpace. And she really was using that to talk about support young women who had been victims of sexual assault or victims of sexual harassment. And then it really took off in 2017 when a white activist, Alyssa Milano, started using it similarly and said if every woman on the internet used that post, they'll see really how much of this is a problem, sexual harassment and sexual assault. And I think something like in 24 hours, it was like millions of people had hashtag Me Too. So as you can see, this is a problem anywhere, work, schools, any place where you encounter people, there's these people who do experience sexual harassment and sexual assault. And so we have some really great panelists today who are going to talk about how they see the issue and how CHRO processes some of those issues and how they interact with it. So one of our panelists today is Laura Roxbury. She's a human rights and opportunity representative with the commission. We have Michelle Dumas-Kuehler, who is a human rights attorney with the commission. We also have attorney Deborah McKenna from the law firm Haber, McKenna, and Dinsmere, and she does employment rights law. And then we should, towards the end, have a special appearance from State Senator May Flexer. So what we're going to do is start with Laura Roxbury. She has a nice presentation. And like I said, feel free to put your questions in the chat, and then we'll take the questions towards the end of the panelists.
Do I need to be able to see the questions?
I can tell you if there's any that we should be answering right now. Okay, I'll monitor it.
Okay, because I wanted to do big screen for me. All right. Can everybody see the presentation? Yes. No?
Yes.
Okay. So I'm Laura Roxbury. I'm an investigator in the Hartford Regional Office, and thank you for being here. Good afternoon. And I'm very happy to be part of this panel and it's an important topic, especially to me, because I was sexually harassed at my very first job in high school. I was 16 years old. I got my first job. I didn't know anything about working, and I certainly didn't know anything about my rights as an employee or any protections that were out there for me. And, we don't teach people very much about that. So I will never forget this. Probably the umpteenth millionth time I complained about the harassment, one of my managers said to me, we've asked him to stop and he won't. What are we supposed to do? Right. And I did not know then that there was an agency that I could go to get assistance with my problem. I thought I just had to live with it. And I don't want you all to have to do what I did. So I am here to talk about this. But the most important thing I want you to get here is the CHRO is here. We handle sexual harassment complaints. If you are having such a problem, please come find us and we can take your complaint and do an investigation. And I'm going to talk a little bit just briefly about how that process works and what the investigation is like so you know what to expect. So there's three main steps for you as a complainant for processing a complaint at the first level. And then Michelle is going to take over and talk about the second level. But so for the first level, the first thing is, of course, taking your complaint. We got to get you filed, right? So normally what we like to do is schedule an appointment for people to take their complaint. You would meet with an intake officer, and they would visit with you, get your information, put together your complaint, make sure it's drafted properly. The statute requires it to be notarized. We're all notaries, so we can notarize it for you right then and get it taken care of. So that's kind of our standard practice. I will say that the pandemic has really kind of upended that a little bit. And so things have kind of gotten wonky because of that. So for a long time, we weren't able to meet with people in person. We were doing phone appointments. So somebody would call you and get your information and email you the paperwork and whatnot. Now we are meeting again with people, but we are also still doing phone appointments. And the point of that, of course, is to accommodate people. And because there still is a concern about how many people are in the building and whatnot. So you can have either option. And of course, if you have an attorney, they can do the complaint for you themselves. But we do offer this service and it's free. So please contact us so that we can assist you with that. And we do provide accommodations too for appointments. We have an English line, we have a Spanish line. If you have another language that you need, we have a language line we can use to call in. I've taken TDD calls before. So, hopefully language will not be a barrier for you. And additionally, if you need assistance, especially with sexual harassment complaints, a lot of times people have come through a very difficult situation. So if you need an accommodation based on the trauma that you've been through, we're glad to offer that as well. If you need a support person or you need extra time or breaks during your appointment, we can do those kinds of things because, we want to help you get filed. That's the important thing. And we want to assist you with that as much as we possibly can. So there's that. So you go, oh, how do I get an appointment? Well, call one of our offices. We divide our state up into 4 regional offices. There's one in Bridgeport, that's our Southwest region. We got the Waterbury office, which is West Central. The Capital Regional office is in Hartford, that's where I am. And then we have the Eastern Regional office is in Norwich. And all this contact information is also on our website. So if you go to the contact page on our website, it will have information about, which offices handle what and how to contact us. But the most important thing is just call an office. I mean, if you call the wrong office, we're going to help you get plugged in with the right office. We're not going to just go, oh, you're in the wrong place. No, we're going to help you get it because we want you to get filed. We want you to get into the right place. And the other thing to remember is you have 3 days when a discriminatory act happened to file. And see, it's really hard when you're doing sexual harassment ones because we understand that people have to take care of their mental health. Sometimes there's things that you have to do to take care of yourself, and you need to do that. But we also want you to be mindful that you only have 300 days to file from when something happens. So the sooner that you can get in touch with us, the better it is so that we can make sure that there's no deadline, that kind of stuff. So And that's, one of the other reasons we do an appointment. We don't want your complaint to get kicked out on a technicality. We want to make sure it's filed timely and in the right way so that you get a full and fair hearing of your complaint. So calling is best. We also have email addresses on our website for contact. You can email us. A lot of times, to be honest, I have to email people and say, please give me a number so I can call you because I have a million questions and it takes longer in email. But if that's what you need to do to get filed, we can do the email. Before the pandemic, we also had a lot of walk-ins that would, people come in and we meet with them, give them an appointment. We've been able to do that less. With the pandemic, the buildings were shut down. And I don't know how it is in every office, but at least in Hartford, if you don't have an appointment, the security guard is not going to let you in. So it's always best to call us. That's the most ideal. And again, it's just, they're still restricting the number of people coming into the building and whatnot. And so we just ask that preferable to call. If that's a problem, though, there are, other options. And I do want to take a moment and just kind of acknowledge that, this is kind of an awkward thing to file a complaint about. People are, you've been through a difficult situation. People are angry, they're confused, they're upset. It can be embarrassing and awkward to have to tell us what happened. And we get that. It's embarrassing and awkward sometimes as an investigator, because then you have to go in and ask somebody, did you say blah, 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 blah? And this is not something I would ever say in my personal life, but I have to ask. So we totally understand that this can be difficult for you. And I just want you to know that you're talking to people who understand, have been there, or have handled such kinds of complaints before. And so you don't have to be embarrassed. You don't have to feel uncomfortable about it. But we're going to acknowledge the fact that it can be difficult for people. And we understand that. And we're going to work with you. So don't let that discourage you from filing, because we want you to come in. And we want to also not cough all over you. And our hope is that in the end, that the process is empowering to you, that it is maybe cathartic for you. I mean, that's our ideal. But we want to be here and assist you, and we can't do that if you don't come and let us help you. So that's the number one thing, is to get you in the door. Once you've filed, we send notice to the party that you're filing against. We call them the respondent, employer, other person, whatever, whoever you're filing against. So we send the notice to them. They have to submit an answer in writing, and you get a copy of that. And if you want to, you can also do a rebuttal to what they've said. And then all of that goes to our legal department, and they have to make a review of the file. And again, this is why we make appointments, so that we can make sure that your complaint doesn't get kicked out on some kind of technicality or something. But the next big step for you after it goes through that initial process is the mediation. And we're required under the statute to have a mediation. And the purpose of that is to give the parties a chance to try to resolve the complaint ahead of going through the investigation process. And again, this gives you our hope is that gives you a chance to have some control over the resolution of your complaint, because you are participating in the mediation and you're naming what you need to be able to resolve that complaint and be able to move forward in your life. And so we want to offer you that opportunity. And I always tell people, it's everybody's in a different place and everybody's situation is different. And what they need out of the investigation or the complaint process is different. And so that's a choice that you have to make when you get to those points. So when you're at the mediation, for some people, having to face their harasser in a hearing might be difficult. Or maybe they just want to go ahead and move on with their life and focus on other things. And if making a resolution at the mediation stage will help you do that, and we can do a settlement for you and let you move on, we're glad to do that. But if you are, if it's more important to you to have, go on the record and have your say, we understand that too. So the point is that there's multiple options in here for the process for you to get what you want to get out of the complaint process. So we're going to offer you the opportunity for the mediation. There's pros and cons to both. You can get a faster relief if you get the mediation, but maybe you want to have a full hearing and then you want to go on to the investigation. Whichever you choose, we're going to make that available to you. So if you resolve at the mediation, fine. If not, you just go on to the next step, which is the investigation. You're assigned to an investigator, who's the person who will do the actual investigation of your complaint. Our kind of default at the agency is to do fact-finding conferences where we bring everybody together and we take testimony from people all at once. And again, with sexual harassment complaints, sometimes that's really difficult. Sometimes it's a lot to ask of people, particularly with whatever the complaint is about. You know, if it's a minor, I should add that if it's a sexual assault complaint, we actually can take those anonymously. So if it's appropriate to the situation, the investigator does have the authority to opt to do witness interviews as opposed to a fact finding. Either way, though, you're going to get the opportunity to have a say and tell your story. We want to give you your voice as part of the process, and we're going to make that available to you. So the investigator is going to interview you. They're going to collect whatever records and do, you know, whatever the documentary evidence is. If you got naked pictures, we're going to look at them. If you got dirty texts or emails, we're going to look at that too. We don't love it. We're sorry that you got it, but you know, it's necessary in making our assessment. So the investigator is going to talk to people. They're going to look at the records. They're going to make an analysis of the facts of the situation, and then they're going to issue their findings, whether or not it's reasonable to conclude that you've been discriminated against or not. And I know I've blasted you with a lot of information there, but absolutely the most important thing is to know that we are here and we want to take your complaints, and there is a place, and you don't have to do what I did and just live with it. And tell your friends, if you know people. I know when my nephew and niece started their first job, I made a point, because of what happened to me, to say to them, you know, there is such an agency and you don't have to put up with that. And so that's really the big thing, is that we're here and somebody like me is waiting to help you. All right, so questions?
So we don't have any questions yet, so that's great. We'll save them all for the end.
Okay.
And thank you, Laura, for the beginning part of our process. Next, we're going to have Michelle Dumas-Kuehler, who is going to talk about the next step. So after a cause finding, as well as a little bit about the Time's Up Act and the sexual harassment training that the Commission provides.
Awesome.
The presentation right now.
Hello, everybody. So let me just get my PowerPoint up. Can everybody see it?
It's working on it.
Can you see it?
Yes.
Yes.
Okay, perfect. So hi, everyone. I'm Michelle Dumas-Kuehler, and I work in the legal department at the Commission on Human Rights and Opportunities. And back in 2019, thanks to a lot of help from Senator Flexer, who will be talking to you all soon, we started the implementation of the #MeToo Time's Up bill that required a large expansion of the sexual harassment training and coverage requirements of our statute. So I'm going to start with that in my presentation. The slide advanced, right? Sometimes I have a problem with that in my computer.
Not yet.
All right, are you seeing the next slide?
No.
See how I knew that would happen?
Take control from me, Michelle. Did you?
It's like it's frozen.
Yeah, that's right. Okay, so hold on. Let me go back here. Let's do this. Okay, how about that? How about now?
There we go.
Yes.
Yes.
Perfect. This is not my first rodeo, as you can see. So back in 2019, with the implementation of the new act, the commission was given a new host of responsibilities as it related to expansion of the sexual harassment training requirements. And those training requirements were expanded for both existing employees and new employees. And what that meant was, as of October 1st of 2019, all employers, and that means employers who have 3 or more employees, were required to provide sexual harassment training to those employees. Prior to the change in the act, only employers with 50 or more employees had to provide sexual harassment training to their supervisors only. So you could see that's a big difference in who needed to get training. It was a humongous change, and who that would be, and it really meant a lot of people. So for those of folks who had employees as of October 1st, they had to be trained within 1 year. That would be September 30th of 2020. And for those who were hired after October 1st of 2019, they had to be trained within 6 months. There also were new notice requirements, meaning that posters needed to be printed, and that sexual harassment guidance needed to be provided through the workplace, and if it wasn't available, then connections needed to be made to the CHRO's website in order to provide information to employees by employers about sexual harassment, places to file complaints, not only the commission but internally, so that everyone was aware that sexual harassment was illegal and where they could go to file if they needed to file a complaint. Because it's one thing to know that it's illegal, it's one thing to know what sexual harassment is, but it is meaningless if you don't know what to do when this is happening to you. And so it was important within the statute that happened, that those where to go, what to do was put into place. So the other thing that was required to do was that the commission was tasked with putting together a 2-hour free sexual harassment training, comprehensive sexual harassment training, the statutes, and the practicalness of what sexual harassment means in Connecticut. And so we did. And as of October 1 of 2019, that online sexual harassment training rolled out. And I am happy to report that hundreds of thousands of people in the state of Connecticut have been trained. And as part of that training, the commission also put in place a email address and a telephone line so that anyone who had questions about sexual harassment, about the training, anything that related to that, could contact somebody at the commission. And that somebody was generally me and Robin Fox and Kim Jacobson. And you probably still will be talking to us to this day. We fielded thousands and thousands of emails and calls related to the passage of this act, and people who had really insightful and great questions and comments about the training and about sexual harassment in general. Now, of course, we all know what happened in March of 2020. And so that really kind of put a stop to the training happening in the way that we all thought it was going to happen when we were implementing this. So by many extensions through executive orders, the requirements that would have been completed through September 30th of 2020 really were extended all the way through May of 2021. And so as of now, all of those existing employees need to be trained. These are the changes in the statutes, just for those of you who love statutes like I do. This is where they're located so that you will know it's real. You can go back and take a look at that because I don't have a ton of time. So the sexual harassment poster is available on the commission's website. You do not need to create it all on your own. For those of you who are employers, you need to provide the sexual harassment information or a copy of it within 3 months of employment for the existing employees, and then for new employees as they come in. And that can be done through email. As a best practice, I always recommend that people do it annually after that. Employees who have 2 or less, so this happens every now and then. the management, not everyone has 3 employees. If you have 2, you do need to also train them. The supervisors need to be trained. That training that you get is good for 10 years. It's pretty incredible. It's good for 10 years. So once you get it, it is good for 10 years of time. New to the act is the portability of it. We very early on realized that people were working different jobs and they were needing to get trained by all of those different employers, particularly, say, journeyman electricians and people who worked as CNAs or nurses, people who might work for a couple different employers under the statute as it was originally written, would conceivably have to take the training several times. So as of October 1st of 2021, if an employee took sexual harassment training provided by the commission, which we have online for free. Did I say that already? It's free. They would be able to port that training within 2 years of taking the training. So that if you took the training in May of 2021, then you would be able to use that training for the CHRO training for any of your employers until May of 2023. I have to say, I can say from answering a lot of calls and questions, really make sure you know where you put that certificate, especially if you're going to go to different employers. We get that call a lot. We automatically generate that certificate when it's important that you hold on to it if you do get it in case you need to show it to somebody. Now, in our old statute, we didn't have as robust of protections if there was violations of the statute, and that was important to put into this statute. And so we did. And so what those protections are essentially a fine if you don't comply with the statute. And the fine is $750 for failure to train or failure to post. And the commission has the ability to inspect employers for not doing those. And that's either on based on a complaint or knowledge of an employer who is not complying with the statutes. Another question we get a lot too is whether that $750 for non-compliance is per employee not trained or per employer who has not done overall training. And I will say that that has not been litigated because we've really kind of just gotten to the end of the training deadline actually passing. And so it will be decided, whether compliance is per person, which I'm not going to speak on behalf of the commission. I will speak on behalf of myself. For really robust enforcement of the law, it would likely be important to have it per person, but someday someone will decide that, so just keep that in mind. I'm going to move along. The statute of limitations to file sexual harassment complaints also, or all complaints to the commission, also changed with the passage of the act. And what was used to be 180 days to file from the date of the discriminatory incident changed to 300 days. So that was a significant increase, and that was really brought about by the fact that 6 months may not be enough time for a lot of people, especially when we're talking about sexual harassment. It's very personal, can be very difficult to talk about, and having the extra time to come forward really was important. There was a kind of a little bit of a missing piece a little bit in the statute, and so that was remedied in the last session. Prior to that, housing and non-agency related public accommodation complaints still had 180 days to file. Now that too is 300 days. So I will say there's a bit of a technicalness about that. If you have a question about whether your complaint is going to be timely, I really, really encourage you to reach out to us. We are here to help, and we will let you know. But I would always, as a rule of thumb, all of the employment complaints are going to be 300 days. It's housing and public accommodation, which may be a little bit different. Now, moving on to post-investigation reasonable cause finding. So once we've had a reasonable cause finding, what happens? Well, a lot of stuff happens, as a matter of fact. If you have a housing case, we got this reasonable cause finding, and if the case doesn't settle after the reasonable cause finding, then it gets certified to public hearing. But for our housing cases, they can go through what we call an election process, and that's the statutory site for that. And they go into court. So we litigate cases here at the commission, both in court and at the Office of Public Hearing. But generally, our employment cases will go to the Office of Public Hearing. Some of them, there may be defaults, there may be some other processing, but generally most of them are going to go to our Office of Public Hearing. So we certify our cases to the Office of Public Hearing. Some of our cases, by agreement of both parties, can be prosecuted in court. And that includes employment and public accommodation cases. And so if the parties agree to take their claim into court, the commission can bring those cases by the private parties into court. If they do not go into court by agreement, then they will go through what we call an initial hearing conference. And that's a scheduling conference to set all of the dates for what will lead up to the actual public hearing. And that initial hearing conference has to happen within 45 days of the certification. The requests for production are really our form of discovery. We do not have the expansive discovery here at the commission that one would have if they were litigating a case in court, in federal court, or in state court. So we're limited with the types of discovery, and it's paper. We don't have interrogatories. We can conduct depositions, but it has to be by agreement of all of the parties. I can say in my 16 years here at the commission, I think I can remember one case where the parties agree to depositions. It's very rare that that happens. After the discovery period has happened, we exchange witness and exhibit lists, and we go for a pre-hearing conference, and then we have our public hearing. And our public hearing process is very much like a hearing in court, except we have relaxed rules of evidence. So that means that what gets in as evidence, documents, testimony, the standard is not at the level that it is in a court, federal or state court proceeding. It's at a level that is dictated by the UAPA. It's it's not that there is no evidentiary objections that can be made, but it's just at a different level here at the administrative process. Once all of the briefing is in, the hearing referees, of which we have 3 hearing referees by statute here at the agency, and we're really excited that 2 more will be joining us very shortly to make our office really robust. Those referees have 90 days in order to render a decision once the post-hearing briefs are in, so roughly about 3 months. If there are the parties don't agree with the referee's decision, then the decisions of our referees are appealable to the Superior Court. They go to a special docket that's in the New Britain Superior Court. So what type of damages are we looking at when we talk about cases that come before our Office of Public Hearing? Sometimes it's specific performance, meaning in say a housing case, if it was a specific unit that you were looking to rent, that could be awarded as part of the damages that you're seeking. A lot of the time it's monetary damages. So again, for housing cases, it could be differences in rent, storage expenses, moving expenses. If it's a employment discrimination case, it could be back pay if you were let go, or if there's a pay differential. It could be front pay. You may not have a job that was the equivalent of the job that you had in terms of salary, and so you could be looking for that pay differential moving forward for some period of time. It could include the loss of the value of your benefits, pension, dental benefits, health benefits. There's lots of different factors that go into the damages that you can receive here at the commission based on your loss of a job, you're not being hired from a job, your failure to be promoted, all of the things that go along, and including harassment. So when we're talking about sexual harassment, we're often talking about a hostile environment. And where that might not lead to an actual pay differential, it could lead to what was next on my list, which is emotional distress damages. It's very difficult to work in an environment that is permeated with discrimination. And so that damage has an equivalent value. And I always express this with difficulty because it is very difficult to put a dollar value on somebody's emotional distress. It's one of the most challenging parts of my work here is equating the two. They're not equatable, but we have to do it, and we have to try to do it at least. And that is the damage that you can receive here at the Office of Public Hearing as an award. Attorney's fees and cost of the litigation, and then interest that goes along with the award. That is the extent of my presentation. I look forward to your questions when the time comes.
Thank you, Michelle. And I just want to point out that Darcy did put in the chat the CHRO Sexual Harassment Prevention Resource page. So you can just click on that, and that will lead you to all the resources that Michelle had talked about a little bit earlier. So that's right there in the chat function. And you could also find it if you went to our webpage. So the Connecticut Commission on Human Rights webpage, all of those resources are also available there. So we are going to go to our next speaker, which is attorney.
Can I butt in real quick?
Sure.
Sorry. I did notice that neither Michelle nor I mentioned this, and I think we should, that you are protected under statute from retaliation for filing a complaint with us. And that is very important to know. So if that is one of your concerns that keeps you from filing, don't let that hold you back, because we can help you with that too.
Very, very good addition, Laura. Thank you for that. And so now we'll have attorney Deborah McKenna talk about her piece, which is a little different because she's representing the direct employee who suffered a harm at work. So without further ado, attorney McKenna.
Thank you, Robin, and thank you for inviting me to speak on this panel. As Robin indicated, I am a plaintiff's attorney. I'm a partner at Haber, McKenna & Dinsmore, and we have an office here in New Haven and another one in Hartford and one in Springfield. I personally have advocated on behalf of employee rights for 25 years. And so I've spent a lot of my practice particularly focusing on advancing issues like sexual harassment, sex discrimination, pregnancy discrimination, and whatnot. So can everyone see the screen?
Yes.
I just want to make sure we can see the screen.
Yeah.
Okay. So I thought that part of what I'm going to talk about is sort of what happens after the CHRO, but I thought it would also be useful for folks to sort of understand ways you could advocate for victims of sexual harassment even before they get to the CHRO, and sort of to put them in the strongest place possible going forward. So what is it like to represent an employee who has been the victim of workplace sexual harassment? It's pretty difficult in the sense that it can be both emotionally draining and rewarding. You're dealing with folks who are in crisis, and maybe it's the harassment has taken the form of unwanted texts or a hostile work environment. Maybe it's at the other end of the spectrum, and there's actually been a sexual assault. But chances are, if you are finding yourself representing someone who's been the victim of sexual harassment, that person's probably going to need a lot of support. And there's probably going to be things that they need that you also, as an advocate for them, can't necessarily provide. And so it's also good to sort of have other resources and think about other ways that you can help that person. For example, you may have an employee who needs to be out of the workplace. And so there are other types of protections, things like the Family Medical Leave Act or leave or accommodations under the Americans with Disabilities Act. There may be an entitlement if the employee has been there for enough time, or if the employer provides them to short-term or long-term disability benefits if the harassment they've suffered has caused them some sort of emotional harm. We do frequently get calls from folks who have been assaulted at work, sexually assaulted, and are diagnosed with PTSD and are trying to figure out how they navigate that workplace. And so there are options for them. So it's just to give you the overview here. So what are sort of 4 things that you should think about doing if you're advocating for someone who's been sexually harassed, even before you file at the Commission on Human Rights and Opportunities. These are our sort of sexual harassment survival guide tips that my firm and I have put together. So the first thing that you have to do, and this may sound sort of counterintuitive, right, is you need to tell the harasser to stop and that their behavior is not welcomed. Why is this important, right? I mean, isn't it enough to simply walk away, or, you know, simply not engage in, maybe if it's an inappropriate text? One of the reasons it's important is because the way our laws have developed require that you, as a victim of sexual harassment, actually show or prove that the conduct that's engaged in was unwelcome. You were not a participant. This was not a consensual relationship. This was not a flirtation back and forth. This was something that you really didn't want to participate in, had no interest in. And so it can be scary sometimes, particularly if there's a pretty big power differential between the person who is engaging in the harassment and the victim. But it's important. And so, you know, we really do try to coach folks up on, you know, saying, I'm not interested, or I don't find that funny, or please stop, I don't like that behavior. But that's the first thing that you should be thinking about if you have a friend or you're advocating for someone who's come to you and explained that this situation is happening at work. The next thing that you should think about, and that we advise folks, and that I think is, if you're advocating for someone who's experiencing harassment, encourage them to document the harassment. There's lots of different ways you can do that. You can take notes, you can email yourself what happened that day. You can take screenshots of text messages that you might have been sent, or save a voicemail message. You can text a friend about what happened. You could, if you're seeing a, you know, if someone is seeing a treater, they could tell the treater what happened. What you want to try to do is have a as contemporaneous as possible record of the harassment. I know, you know, from having done this for a long time, I know, so for folks, you know, particularly if what they're getting is unwanted, explicit text messages, which people do all the time, and it amazes me, but that's still a pretty big part of these types of cases. Sometimes they'll delete them because they're afraid their kids are going to see their phone, or it was just, you know, gross and disgusting, and who wants a picture of someone's naked body on their phone that they didn't ask for, right? But it's important to preserve that, because that's a really critical piece of evidence, and once you've deleted it, you really can't get it back. Usually by the time someone makes it to my office, you know, it's too late to get a subpoena to a phone company, and not to mention you really can't even do the, you know, folks, I think, because you see TV, they think, oh, can't you just subpoena those text messages? You can't. I mean, you can try, but phone companies only save their records for a really short period of time. And by the time you are in a place legally to actually even be able to get a subpoena, you know, which is a court order forcing them to turn over those text messages, they've been long deleted. So I would advise folks, no matter how offensive, no matter how embarrassing, even if you feel like maybe it didn't put you in the best light, maybe they sent a really disgusting joke and you kind of responded LOL because you didn't know how else to respond because you didn't want to upset your supervisor. Those are things you really should try to save and to document the harassment. The third step is that if you are advocating for someone, you should encourage them to get a copy of the company's harassment policy. And it could be in your company handbook, it could be online, but under our sexual harassment case law, particularly the way our United States Supreme Court has developed this area of law, it's important that you understand what your employer requires you to do if you need to make a complaint of sexual harassment, and that you read it and you figure out how you make the complaint of sexual harassment. Again, that might be a little scary, but it's an important step. And why is it important? Because if you don't follow your company's policy, the employer may have a defense. They may be able to say, we didn't know about the harassment because you didn't follow the set procedures. And that might be a defense to your claim of sexual harassment. So it's important to find out the policy. And then the final step is it's really important to complain in writing if possible. You follow the policy. Usually the policies don't specify that you have to do it in writing. They usually just say make a report, right, to a supervisor or human resources, or they'll designate some other person. But from a practitioner's view, a complaint in writing is the best way to handle that. It leaves no ambiguity. You don't end up in a situation where, the human resources person is saying, well, I didn't really understand that that was a sexual harassment complaint. I mean, you said you were uncomfortable, but I didn't really think that what you meant was that he was inappropriately touching you. So it's best to be as clear as possible. Again, these are scary steps, but as Laura pointed out, it's illegal. It's important. I mean, it's illegal to be retaliated against, and they are really important that you follow them. Because you want to make sure you're putting yourself, or you're advocating for someone to put themselves in the strongest place if they're going to actually go, take that next step and file a claim with the Commission on Human Rights and Opportunities. And now all complaints, if we're talking about an employment complaint, but not a claim of sexual assault, we'll leave those aside for a minute, but just if you're talking about a sort of a general sexual harassment complaint, you have to go through the commission process before you can ever bring your claim in court. It's called exhausting your administrative remedies. So it's important that you take these steps, at the beginning, if at all possible. On to the so can your employer force you to take a different position away from your harasser if you complain? This issue comes up. In fact, I had a potential client today call and ask me this very question because she had complained about a situation and the employer was saying, well, there's not much that we can do. Hold on, I think that moved too fast. There's not much we can do about that. You can take this other very less desirable position, different hours in a different location. When the 2019 revisions were put in place to the Connecticut Fair Employment Practices Act, which Michelle touched on, one of the provisions was that if an employer was going to take some sort of immediate correction action in response to an employee's sexual harassment complaint, that they could not modify the terms and conditions, the conditions of the complaining person's employment without getting approval in writing. And so, because this was pretty common practice, right? The person who's the victim of the sexual harassment would complain, and lo and behold, the harasser couldn't be moved for whatever the reason was, and the victim was finding him or herself in a less advantageous position, maybe in a position where there's less overtime or the shift was different or whatnot. And so this is a pretty this was a good, strong revision to the law. It hasn't really been litigated yet to see how that's going to play out, but I think that it's an important tool for employees to use. So can your employer fire you for complaining about sexual harassment? Employers fire people all the time. It doesn't make it legal. I always tell folks, listen, I don't have a magic wand. I can't stop them from doing that. We really very rarely do courts grant injunctions to stop an employer from firing someone, but that doesn't make it legal. And so that means if you do get fired for making a complaint of sexual harassment, you have a legal claim that you can bring against your employer for that. It's called retaliation. So I touched on this at the very beginning, the other considerations that you might have if you're experiencing sexual harassment. So if you are advocating for someone who needs to take leave, there's a certain amount of state and federal FMLA leave they might be eligible for if their employer is large enough and they meet the eligibility requirements They might be able to take short-term or long-term disability. And if you've been diagnosed with a condition like anxiety, depression, PTSD, your employer may have some obligation to accommodate you, both under our Fair Employment Practices Act or the ADA. And I would say if you found yourself advocating for someone in that position, it probably makes sense to talk to an attorney who can help weed you through that, because there's different time limitations, different requirements, to really see how best to try to protect an employee who's still within the workplace and trying to save their job while at the same time, sort of fighting against the sexual harassment. So now what happens if you or you're advocating for someone who wants to bring their claims in court? You heard Michelle talk about the fact that after a cause finding, you can have a public hearing. You can also ask for a release to file in state or federal court. Again, that's going to be governed by the size of your employer. But there are also some deadlines that you should pay attention to. The statute right now, under our Fair Employment Practices Act, requires that if you're going to bring a claim in court, in state court under SFIPA, you have to do it within 2 years of filing at the commission and within 90 days of when the commission releases it. Under federal law, under Title VII, which prohibits sexual harassment, you only have to do it within 90 days of the release. It doesn't matter if your case has been sitting at the EEOC for 5 years. So you should pay attention to the deadlines. And if you have a situation where there's an assault, like a sexual assault, that has its own timelines. You should preserve any evidence, going back to the very beginning, text messages and calls and voicemails and documents. And if possible, you may want to talk to a professional about any emotional distress you've experienced, both because the person who's experienced the harassment probably needs to have that outlet. Maybe it's a support group or a therapist, but it would also help bolster any claims that you would have for emotional distress, as well as perhaps explain why a person may stay in an environment where they've been suffering, experiencing harassment for some period of time. So those are sort of, I didn't want to get into the nitty-gritty of court because I don't think that's appropriate for this particular conference. I'm happy to answer any questions about it. Those are some considerations folks should make if they want to take their case from the court, from the public hearing range into court. With the revisions in 2019, the remedies are now nearly equal. The statute allows for the emotional distress and attorney's fees to be awarded by the public hearing officer. In court, you can get punitive damages as well. I think that that's an open question under the CHRO public hearing officers right now. But again, I'd be happy to take any specific questions. I just really wanted to give you all an overview, and I know I need to give Senator Flexer some time to speak to you all as well.
Thank you, Attorney McKenna. And so, yes, we have our final panelist coming up, which is State Senator May Flexer, who can hopefully speak to why she decided to support the Time's Up bill and just talk a little bit about future legislation and the importance of having some legislation for these sexual harassment issues.
Thank you, Robin. Good afternoon, everyone. It's an honor to be here and be a part of this conversation and to be a part of this panel with Laura, Michelle, and Deborah. And I want to thank the Commission for having this conference today and having this conversation and this group around these issues, and for all of their incredible leadership and advocacy on improving our state's sexual harassment laws. And in particular, I want to thank Director Tanya Hughes and Deputy Director Cheryl Sharp and all of the staff for their great work, both supporting people, as you've heard about today, when they're dealing with sexual harassment in their workplaces, and advocating so that Connecticut can have some of the strongest laws in the country around this. It's a goal of mine to ensure that Connecticut has the strongest sexual harassment laws in the country. I think we're getting there. There's a little more work to do. But as you've heard here today, we've made some great strides in the last couple of years. And I will probably reiterate a few brief points before we move on to the question and answer portion of this conversation. But, we really thought it was critical that everyone knew their rights in the state of Connecticut. As you heard earlier, before this law went into effect 2 years ago, the only people who were required to be trained in the state of Connecticut were supervisors. And it was often only people at larger employers who were being trained around sexual harassment. So one of the main things that those of us that were advocating for this legislation in the state Senate and the state House were really focused on was making sure that all workers knew what their rights were. And as we were talking with people at the commission and other advocacy groups, we knew that universal training was the way to go. We knew that many people, particularly young women or people in their first or second jobs, they were often the most impacted. And they knew, they had that feeling in their gut that the behavior wasn't right, but they weren't people who were being informed of what their rights were and what action they could take to get that behavior to stop. And so I think these changes to the law is going to go a long way and creating a generation of workers who know what their rights are if they're the person who's victim to the harassment, but also know what their rights are if they see their coworkers being victims of the harassment, and can have that bystander intervention that we hope to strengthen and have more people step up to say this kind of behavior is unacceptable in our workplace. We knew that many workers, when they did come forward to say that they had sexual harassment, as you've heard about today, they faced retaliation. And people were suffering from speaking up, from coming forward, for being so brave and saying, this is what's been happening to me, and this is not legal, and this is wrong. Too many workers were being retaliated against. And so I think the changes that we've made to the law in the last 2 years have gone a long way to hopefully mitigate that. But I think there's more work to be done. As you just heard about, what we really heard was that oftentimes the solution for an employer, when someone came forward and said they were a victim of sexual harassment, was to move the victim. And so it was the victim who suffered the consequences for coming forward and dealing with that harassment instead of the perpetrator. And so I was interested to hear Deborah's comments in particular about how that's playing out in the real world and hasn't been really litigated yet. I'm hopeful that the statutory language that we passed is strong enough to make sure that those corrective actions don't result in changes that the victim of the harassment doesn't want to see happen in terms of their position or the circumstances regarding their employment. I'd love to hear more this afternoon and the time that we have for questions and answers about what's next. I know the commission has some great ideas on things we can do to strengthen our law, to look at, you know, how severe does the harassment have to be to qualify. And I personally think we need to look at some compliance issues and make sure that all employers are complying with the new training requirements. And we may need to revisit some of the penalties. We did strengthen the penalties in the legislation that passed 2 years ago, but let's make sure that those penalties are severe enough that all employers are ensuring that their workers know what their rights are and know how to rid their workplace of sexual harassment. So with that, thank you very much for having me here today. Look forward to the continued conversation.
Thank you so much, Senator Flexer. So now we are going to open this up to questions and answers. You can do that either by typing your question into the chat function for any of our panelists, or by raising your hand, and then I can call on you and you can turn your microphone and your camera or whatever you feel most comfortable with to ask the question. But I would like to start off just about the standard that it typically takes to prove a sexual harassment case and the standard of severe and pervasive. And if any of the panelists had any thoughts about perhaps thinking about changing that in the legislation, or any thoughts about that being a very high burden to prove.
So sure, if you all don't mind, I'll just jump in because I'm constantly amazed when I read cases. Typically within our federal circuit, the Second Circuit, right? We just don't get as many in state court, but still, at how high that standard really is, right? Like, I mean, I was reading a case not that long ago, and the literal words were, well, you know, he only forced himself to kiss her once or something. Like, okay, that's enough, and that's not making that's not enough for some hostile work environments for some courts. what does it mean to be severe or pervasive? I think that, we kind of know, well, rape fits severe, and maybe that only has to happen once. We have at least one case that says that, but everything else, it's up and down. And the more recent cases the Me Too movement hasn't really hit a lot of those decisions. So we're sort of dealing with more conservative courts from the 90s. I have to say, like, if I want good language, actually go back before that, because I think the earlier cases, some of the court language is actually stronger than what we had in cases in like the 90s and early 2000s. That's my 2 cents. I think it's too high. I don't know. I'd be curious to hear Michelle or Laura jump in.
I would agree with you on that, Attorney McKenna. Yes, I mean we agree, and I think I think we've always seen the changes to the act as kind of the start and not the end of what we would like to see at the agency in terms of progression and protection and expansion. And so certainly we would be looking to change that definition to not make it so difficult for people who are being harassed to prove their claim, because severe and pervasive is a very high standard. And as Attorney McKenna expressed, proving that in court is, and we're all, it is a subjective standard, and I know you likely probably do a lot of jury trials too. I mean, it's a very high burden to meet. And so, yes, the commission is like I said, this was a process, and Senator Flexer can probably chime in on that. We don't always get all the things that we want in the first time around. And so we most definitely are revisiting that this session, and we'll continue to make it as equitable as possible.
I would just chime in really briefly that you're right about that process. We don't get everything we want. This took 2 times. We first tried to pass this law in 2018 and weren't successful until 2019. And I do think the standard of severe or pervasive really needs to be revisited. And it's something I look forward to working with the commission on in the next legislative session. And I would welcome any examples that anyone has of cases where clearly something was wrong, but that standard got in the way of having the appropriate corrective action. I think that would go a long way as we work next year to advocate for a change in the law.
We should talk after this panel, Senator Flex.
That would be great.
We have a question in the chat, which is, does anyone have any suggestions on some ways that we can mitigate the re-traumatization that can occur from going through the process of telling the story, going through an investigation, and litigating? Does anybody have any tools that they try to use to try to mitigate that stress and trauma?
So I would say, I do let folks know at the beginning it's a difficult process, and they are going to at some point have to probably confront the harasser. And so it's sort of important at the beginning to figure out, does your client have a support system? If not, can I sort of connect them with, a support group or a therapist or someone to just help them work through it, right? Because as an advocate, I don't have those skills. I mean, there are folks who are designed to do that. But it's just trying to educate folks too. It's tough. Litigation's tough, and you get some folks on the other side who are defending employers who are just going to be tough, and there's not a lot, and they'll walk right up to that line. And so I think I try to just educate, and and we work through it. We prepare, and you try to get folks more comfortable talking about things too, and just helping them see it's not their fault. They're not in this position because of what they did.
Well, and I think I agree 100%. And I think from the agency perspective, because we do not represent, we're in a unique position because we represent the state of Connecticut, and we do not represent complainants who come before us individually when people come into the agency for investigation. But we do have to be very thoughtful about how we speak and the words we say and the choices of the words we make. Because it is very traumatic for many people who come to us to be thoughtful about whether, the little things, people, when we used to be in the same room, but even now just appearing on the same screen together can be very traumatic. And I think the logistics of how we operate have to be very thought out. In terms of that work, it is very difficult, because the reality is this is an adversarial system for a reason, because we are on opposite ends in terms of the work that we do. And where I work in the legal department, by the time I get a case, we are a party. And so we are in an adversarial position. But I think, we really do try to be thoughtful about what it is that we do, and we need to continue to do that, because people who come here are very vulnerable, and we need to be aware of that when we are working with them on their cases.
Laura, do you have any examples of things that you might, tips or tricks you might use with the more vulnerable individual that you would see come by your office?
So I am pretty protective of all my complainants generally. When I'm doing my fact finding, you're there to convince me, not to argue with each other. So I try to shut that down pretty quick. I'm not going to allow any questions that are intimidating or anything like that. So I'm pretty protective as far as just how the questioning goes. I'm going to do the questionings. My tone's going to be, just questioning, and I'm not going to shine a light on you or anything like that. I want to make people feel comfortable on both sides to talk to me. And, just kind of set a tone for the room. If we need to take breaks, I've done that before. I think everybody needs to take a break. I know I do. So, kind of trying to set an environment where people feel comfortable and they don't feel like they're going to get grilled, because at my level, we're not in court. And so, that does give me a little latitude that some other people may not have, because they're in court and it's a different kind of thing. But with my level, it's not, in that there's no judge over to my shoulder. So on chance, I don't know going in if that person's been actually harassed or not, but on the off chance they were, I'm sure not going to let them be treated like terribly through the whole process. So, and again, I've been through it in that boat. So, there's that, I'm going to be somewhat sympathetic of it. And, I try to be encouraging with people and understanding and protective as they can be. I don't know. I'm a baseball fan. I don't know if any of you guys are. And there's this horrible case that's just come out recently where a baseball player was accused of assaulting a woman, and they had a hearing for the protective order, and the attorney for the ball player was like, I'm not trying to slut shame you, and then pretends to, proceeds to slut shame the girl. And the judge just sat there, and I was so mad, because I thought that would never happen in one of my investigations. I wouldn't even tolerate that. And so there's that. I have a little more latitude at my level, and I try to use it.
Thank
Robin,
you.
if you don't mind, if I could just chime in with a general answer to this. Obviously, I don't particularly have a role in mitigating the trauma that happens for individual victims who are coming forward. But I would just say that we all have a responsibility to try to change the way our culture talks about this. And I think that's one of the big goals that we had in working on this legislation over the last couple of years. We have a really victim blaming culture. And as a legislator, I'm very lucky to work on issues around sexual harassment, sexual assault, domestic violence, and all of those issues. There's this misogyny that's baked into our society. There's this victim blaming that is just baked into the way that we talk about these issues, unfortunately, where, someone comes forward and the comments are about, well, did you see their appearance? Of course, this sort of thing happened to them. Do you know what they do in their personal life? Well, of course, this sort of thing happens to them. And I think we all hear those things in our daily lives, both professional and in our personal lives. And if we all step up and call those things out in the moment when we're hearing them and when we're seeing them, and we stand up for the brave people who are coming forward in these situations and knock down those kinds of comments and each do our own individual part to make that kind of talk and that kind of behavior towards victims unacceptable, I think we can slowly start to change this.
Yeah, that's a really wonderful point, because we have been hearing a lot about, pointing the finger at the woman for what she did or did not do, instead of, trying to teach. I heard a very good friend of mine say recently, like, teach boys to be, good humans too. Like, there needs to be a balance in how we're going to, move forward. So it isn't just like Laura's example, what did you do? What were you doing in that scenario? So I think that's a very important point. And I see Laura's back unmuted. So
I want to add to that. I mean, I don't want it to sound negative here, because I know we have a lot more work to do, but I want to reassure people that the needle has already started moving, and that's really great, because I started doing this in 2004 in a different jurisdiction. And let me just tell you, it's so much less depressing than it was back then. And we have adjusted a little bit. I mean, I can tell you, when I first started, people didn't talk about same-sex harassment. The idea that guys could file was like, what's wrong with a guy that wants to file? Doesn't every guy want to get hit on? So we have definitely moved the needle so that there are protections for people. It's not just a women's issue, which it kind of got shunted away for as a while because of the women's, but it isn't just women. I mean, I remember a guy who came to work complained to me one time, not here, and he was like, I'm going to work on a construction site. The guys are mooning at each other. They're doing all kinds of stupid stuff. They tell dumb jokes. And if I was a woman and I worked there, they would never be able to do that kind of stuff. And I'm a Christian. I go to church, and I don't want to have to go to that every day. I just want to do my job and go home. So we have moved the needle. Now it's not, I remember back in the day when it was like, oh, you had to prove that the supervisor was trying to seduce you in order to have a complaint. And we have adjusted a little bit. So I want to be encouraging to people that if you are out there and active, if you are contacting your representatives and trying to do things to advocate, if you're trying to change the culture, it is working. It's slow but sure. But I really do think that we are making a difference, and we can continue to make a difference. And I hope that everybody doesn't get discouraged by the way things are now, but just recommits to the cause.
Well, on that note of positivity, we don't have any other questions, but if any of the panelists had anything they wanted to say before we go, and if you do have a question, now's a chance. You only have 3 minutes left to get that question in. But if anybody else, any of the other panelists just wanted to say anything briefly, please do. Michelle, you're muted.
Off too. I took my glasses off, so I can't tell. The commission is committed to the enforcement of the civil rights statutes, and part of that is through the legislative work that we do. And so we're always looking to make sure that the statutes reflect what the needs are of the people in our state, and it's always growing and changing. And so, we are here to help everyone, and we want your input too. So please make sure to contact us. Our case processing is how we learn a lot of what's going on, but independently hearing from people is another way too. And the commission can engage in its own commission-initiated complaints if people are afraid to come forward, which happens a lot. I just literally yesterday got a letter from somebody who was saying there's a lot of rampant sexual harassment from somebody in a work environment. And they were afraid to come forward on their own. And so we're going to pursue that. So it's always an avenue that the commission can provide, and that we do provide commission-initiated complaints in these areas. But we want to know so that we can continue to reflect what the needs are in the state.
Well, seeing no other questions or comments, I want to thank you all for your participation today, both the attendees and making it through the whole day with us. We're going to go back to the general conference link right now to get brief closing remarks, concluding remarks. Darcy just put that link in the chat function, so we'll head over there. And thank you again for being here, and thank you, Senator Flexer and Michelle and Laura and Attorney McKenna. We do appreciate your time today.
Thank you. Thank you.